Let's call the case People versus D'Angelo Simmons.
Good morning, Honor. Right now, position for the defendant, Dr. People.
Already in that setting, Ron Brown, Deputy Chief Public Defender, appearing on behalf of Mr. D'Angelo Simmons, who approaches from the lockup. Under today's date and time set for a competency review hearing, does the court have an updated report?
Today's docket moves fast, but make no mistake, this is the kind of courtroom calendar that quietly reveals how the justice system really operates when no one thinks the public is paying attention. Multiple defendants, different charges, different stakes. One judge, Judge Simpson, tasked with balancing public safety, fairness, accountability, and the clock. What you're about to see is not a single dramatic trial, but a rapid-fire sequence of decisions that can alter lives in minutes. Competency reviews, bond violations, substance testing, missed appearances, family responsibilities, plea negotiations. This is the machinery of criminal court in real time, and it's here where patterns emerge. Who the court trusts, who it doubts, and who runs out of patience. Watch closely because the tone is set early. When reports are missing, timelines stretch. When testing doesn't add up, consequences come fast. And when defendants speak, every word matters. Stay with us, because buried inside these procedural moments are the clues that explain why some people walk out the door and others don't. This is not chaos, it's controlled pressure. And how each defendant handles it tells you everything.
My most updated report is from April 8th, dated April 8th, received by us April 14th.
And have, okay,
Double checking, but I believe yes, that's the last one.
That's the last report. I don't know why this wasn't sent earlier or moved up once we got that report.
may I have my client state his name for the record?
Yes,
D'Angelo Simmons.
all right. Well, they would do a review from April 8th. It'll be about July something, so I'll just indicate at this point I don't have a report. I'll set it out basically at 90 days from the date of this report, so hopefully we'll have something. What's my closest date to July 8th?
July 17th.
All right. No, that's fine. That's a Thursday.
Yes.
I'll set that out to July 17th, 2025, 9 a.m. If we do get a report, this one should have been moved up itself, but if we do get a report, we'll move the date up. All right.
Thank you, Honor.
Thank you. Court does call the case People versus Douglas Hill.
On behalf of Mr. Hill. Thank you, Your Honor. I did provide the court with a clean sheet. We're simply asking for a brief adjournment in this case.
If I were to test your client, will you test clean today? And I don't like being lied to.
Probably not.
Okay.
I just
What would be in your system?
I've been tested dirty for cocaine and THC, I believe.
3 successive occasions. Mr. Allen. I have a bond violation report here.
But I haven't even been out a week to get my system clean. I just caught this charge and the bond was just set, so I haven't had time to actually get my system clean.
I have a whole week of testing with cocaine in your system.
We also have a failure to appear for CCOP, is that correct?
For CCOP, what's that?
It's
That's true.
correction stuff.
No, oh yes, they rescheduled my appointment for Monday at 9:30 with the brown guy for the outpatient program.
Yeah.
That yes, because I thought I showed up at 2, it was at 1:30, and then I also dropped yesterday.
Why is cocaine still in your system?
It will not be today.
Well, you just told me it was gonna come back.
Because I haven't dropped clean yet. That's why I assumed that. I don't know how long it takes to leave.
You're
my system.
still using.
No, I'm not.
No, because you want, okay, I'm gonna tell you what, if you're telling me you're not, I'm gonna take you back, I'll call over, get levels, and then we'll see exactly what's happening.
So I got
You want me to do that?
so I can drop today.
No,
I'm sorry. I
you
didn't.
would go back there with my bailiff, I will call over and get levels. If you're telling me that your system is just cleaning out.
My system should be clean.
No, that's not what I'm saying. You're telling me you're not using,
Correct.
right?
Yes.
Okay, then this must be some super duper cocaine.
This exchange is a masterclass in judicial skepticism. The defendant says he's not using. The numbers say otherwise. And Judge Simpson cuts through the contradiction with dry, almost surgical sarcasm. Cocaine levels don't rise on their own. The court knows that. Community Corrections knows that. And the judge is signaling something critical here. Credibility matters more than excuses. When a defendant admits the test will come back positive, then immediately claims abstinence, that inconsistency triggers verification, not leniency. That's why the judge orders levels to be pulled. This isn't punishment yet, it's fact-finding. But it's also a warning. Courts will give people room to be honest. They will not tolerate being misled. This is where many defendants miscalculate, thinking partial honesty buys time. Instead, it invites scrutiny. And once the numbers are in, there's nowhere left to hide. Ask yourself, if you were in the judge's seat, would you believe this explanation? Or would you do exactly what we just saw? Check the data and let the facts speak.
So we'll figure it out. And so what I'm gonna do is, Mr. Allen, you can take him back. We will call over to Community Corrections, get your levels, and then we'll figure out what's happening. Court does call the case, People versus Romeo Serva. Oh, 2 in a row.
Chairman Adish, on behalf of Mr. Serva, who is approaching.
Your name, sir?
Romeo Serva.
Thank you.
Your Honor, we are going to be asking for an adjournment for mitigation, and we would like to address bond, please.
Probable cause conference will be adjourned May 29th, 2025, 9 a.m. I need a green sheet and then that's bond.
As to bond, Your Honor, I wanted to address, I wanted to ask for him to be released on tether. Your Honor, Mr. Servo is 20 years old. He has 2 children that he takes sole custody of.
This is where mitigation enters the courtroom, and it's carefully constructed. Defense counsel is not denying missed tests. Instead, they're reframing the narrative. Youth, sole custody, academic success, employment effort. This is how bond arguments are won or lost. The court isn't being asked to ignore violations. It's being asked to manage risk differently. A tether is presented as structure, not freedom. But notice Judge Simpson's focus. It's not the story, it's the data. Missed tests, reports, dates, consistency. Family hardship can explain behavior, but it does not erase obligations. The judge listens, but listens critically, and that distinction matters. Courts routinely see defendants with real responsibilities. What separates outcomes is whether those responsibilities coexist with compliance. This is a tightrope argument, and at this moment, it could go either way.
He has to take care of them right now. They're in the care of his father and his foster grandfather and foster grandmother who aren't able to actually keep taking care of his children. He has been in school. He has a 4.0 GPA. He just got his transcript back. He had a job interview. He's doing really well. The reason he was missing them is just because he had so many things going on. They were early in the morning. He has these 2 kids. I can assure you that if you put him on a tether, Your Honor, that you will be seeing obviously no missed tests, but no positives or anything like that. He is not drinking. He doesn't drink. He reacts very poorly to it. So we are going to be asking for that.
Yeah, but he wasn't testing on his SoberLink device. I mean, he just wasn't testing like he should.
Yeah, there's 2 that he missed. He was in custody for those. Those are the first 2 missed ones on the report from March. And then he had 4 missed ones, but he submitted a compliant test like within 15 minutes.
I'm talking about, I got that, but his April 24th report from Community Corrections.
I'm not in receipt of that. The last one I have is as of April 23rd. I may have missed it, but
April.
The report that I have, the last test on there that was missed was the 23rd of April. Let me look.
Right, but there should be a bond violation report from April 20, that's dated April 24th, 2025.
Oh, this is the one. Oh, no, sorry. Yeah, April 24th. This is the same one I'm looking at.
Okay.
Okay.
Go ahead.
Yes. As 2 of those were missed when he was in custody elsewhere. 4 of those he missed, but he retested like within 20 minutes, 15 minutes, 7 minutes after the 9 a.m. block. I believe there's only 2 that he missed that he never retested for, and those were the newly added time window. I believe he had either forgotten about those, and I understand that that's not an excuse. He just has a lot going on with school, with work, with his two kids, and that's why I believe having him on a tether would resolve this issue. He should have been put on tether from the beginning, honestly. But if Your Honor releases him on that tether, and he's not missing any of his drug tests, so.
Any response? Okay.
The only thing I'm concerned about was in September of 2023, the defendant was placed on probation in the Oakland County Circuit Court on 2 counts of RIO and an A&B or HIDA. And obviously this offense occurred in June of 2024. So it would have been while he's on court supervision to Oakland County Circuit Court on a similar charge that also qualifies by the defendant's ability to cover.
Your Honor, he is undergoing mitigation for mental health concerns that we're going to provide to prosecution. I've talked to his attorney in his Oakland County cases. He is on probation for those. He's testing in so many different places for so many different things. That's why also he is having trouble keeping track of these tests. And I mean, again, I believe a tether would help with all, huh? What do you want to say?
I just want to tell him that I did ask when I realized it was going to be a problem. So I won't have any problems with it.
Yeah. He's saying that he requested, well, he wanted a tether in the first place, and
When you're saying a tether, you're talking a scram tether?
Yes, sir. And if I was to get that, I wouldn't have any problems. You wouldn't hear it from me. I don't drink alcohol. There's no alcohol in my household. It's just 2 children and I go to school every day.
2 children and some pot, right?
Well, I smoke outside the house and it's never around them.
Okay. Do you have a card?
Yeah, I do. And
Did you give us your card?
I offered to give that to community corrections, but they refused to take it every time I offered it to them.
and his father submitted it. They'd already submitted it to community corrections. I don't know why community corrections lost track of it, but I talked to his father yesterday, and his father said that he sent community corrections a copy of it again yesterday, but that every time he goes to test, he has his medical marijuana card on him and it's active. And I can send that to the court right now.
I will modify his bond, although he may not be entitled to a $25,000 personal recognizance bond, but he needs to be on a scram tether prior to release.
This ruling tells you exactly how Judge Simpson evaluates trust. The bond is modified, but only with a scram tether. Translation: conditional confidence. The court is acknowledging the defendant's mitigating factors while simultaneously eliminating ambiguity. A scram tether doesn't rely on memory, schedules, or self-reporting. It records, continuously. This is the court saying, I'll give you a chance, but I won't guess. It's a compromise rooted in accountability. For the defense, this is a win. For the prosecution, it's protection. And for the defendant, it's a final test. Because from here on out, excuses disappear. Compliance becomes binary. You either follow the conditions or the record speaks for itself. This is modern supervision replacing courtroom debate, and it's increasingly common.
Thank you, Your Honor.
And I've set this over to the 29th.
Thank you, Your Honor.
Thank you.
Thank you.
Court does recall the case, People versus Hill.
I think they were looking for the people.
Well,
Yes, Your Honor, we did receive the results in this matter and I have discussed them with my client. And what the likely outcome will be based on that result.
Pardon?
And what the likely outcome will be based on that result.
Well, just so the record's clear, he had indicated to me that he hadn't taken it, hadn't been using, but his levels started out in May of cocaine, started out on May 7th at 424, then went down by May 9th to 353, but then by the 14th shot up to 889. So anything else you want to say? He's been using.
Your Honor, my client is just asking for a 1-week adjournment in this case. We're gonna have him screened for drug court to see if that's a suitable, a good fit
Probable
for him.
cause conference will be adjourned May 29th, 2 weeks on.
2 weeks. Thank you, Your Honor.
Absolutely. 2025, 9 a.m. His bond is revoked.
And Mr. Hill?
People versus Sherry Hughes.
If you originally looking for the people.
Morning, Your Honor. Mike Gaddy, Assistant Public Defender on behalf of Ms. Hughes, who's not here. Judge, I did submit a green form. I did receive a call from Ms. Hughes' mom yesterday stating that she was at St. Joe's psych ER. I got a call around 8:30 saying that they're waiting to be discharged. And I don't think she's in a position to actually be still going to court today. I'd ask the court to excuse her presence and adjourn this matter.
Well, I'll need some documentation, but Mr. Getty, but I'll adjourn this over to the 22nd, 1 week out.
Thank you, Judge. I will.
2025, 9 a.m.
This brief exchange highlights judicial restraint. The court is told the defendant is hospitalized. The judge doesn't dismiss the claim, but doesn't blindly accept it either. Documentation is required. Still, the matter is adjourned. This is balance in action. Courts must protect due process while preventing abuse of absence claims. Judge Simpson grants time, but anchors it to verification. No emotion, no suspicion voiced on the record, just conditions. This is how legitimacy is maintained. Even when cases vary wildly in severity, the process stays consistent. And that consistency is what gives the court authority when it does act decisively elsewhere on the docket.
Thank you. I will provide the discharge paperwork when I get it. Thank you.
Court calls the case of the people versus, you said it's LaDonta Skinner. I don't know why they have it this way.
We're ready in this matter, Your Honor. Lauren Brown, Deputy Chief Public Defender, appearing with and on behalf of Mr. Skinner, who approaches the podium. Skinner, please state your name for the record.
LaDonta Skinner.
Thank you. Your Honor, today is the date and time set for the probable cause conference. We are respectfully requesting this matter be set for preliminary examination.
Both matters.
Yes, please.
Discovery is complete.
Yes, to the best of our knowledge, discovery is complete.
People have their witnesses available the 27th. Preliminary examination, May 27th, 2025, 9 a.m. That will be before judge.
27.
Continue.
Okay, Your Honor, what does the court show as the bonds in these matters?
1,000 cash surety on the case ending in 5724. And on the other matter, same thing.
10%.
Both are 10%, Your Honor.
Hmm?
Both are 10% allowed.
This is a clean example of procedural clarity, and it matters more than it sounds. Bond terms can be confusing even for defendants who have been through the system before. Judge Simpson slows this moment just enough to confirm what applies and how. A 10% bond means the defendant does not need to post the full amount, only a fraction to secure release. That distinction can determine whether someone waits in custody or prepares their defense from home. The court confirms discovery is complete, witnesses are available, and the case is moving to preliminary examination. Translation: this case is advancing on schedule. No excuses, no delays. There's no drama here. But that's the point. When cases are orderly, the court moves efficiently, and that efficiency becomes the baseline against which later disruptions stand out.
It is cash surety 10%.
Okay, all right. Thank you very much, Your Honor.
Court calls the case people versus Joel Stevens.
On behalf of Mr. Joel Stevens, who is approaching.
Joel Stevens.
All right.
Your Honor, we are going to be setting this for preliminary examination, please.
Discovery is complete.
Yes, Your Honor.
People have their witnesses available the 27th. Preliminary examination, May 27th, 2025, 9 a.m. That's before Judge Washington. Bond will continue.
Thank you, Your Honor.
Court does call the case people versus Davian Thomas.
We're ready in that matter, Your Honor.
Andrew Children, appearing on behalf of people.
Lauren Brown, Deputy Chief Public Defender, appearing with and on behalf of Mr. Davion Thomas. Mr. Thomas, could you state your name for the record?
Davion Thomas.
We're doing the plea.
Yes, please.
The plea form indicates a defendant will be pleading guilty to an added count 3 of larceny by false pretenses, 200 to 1,000 to 1 year offense. Upon his successful plea to that charge, counts 1 and 2 would be dismissed, and it is okay for him to seek hideout in the case. That's the agreement of the parties, as the court understands it.
That is our understanding, Your Honor.
May I have him sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth, so help you God?
Yes,
State your name.
Davion Thomas, Your Honor.
Sir, it is this court's understanding that you're going to be pleading guilty to the charge of larceny by false pretenses, $200 to $1,000. That is a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. The fine could be increased at 3 times the value of the property, which is the subject matter of the theft. If that's greater than $2,000, that would become the maximum fine. You understand that?
Yes, Your Honor.
You understand also, sir, that while I'm taking your plea, I would not be your sentencing judge. You would be sentenced before Judge Barr in the 14A2 court. Do you understand that?
This plea colloquy is textbook, and that's intentional. Judge Simpson meticulously walks the defendant through rights, consequences, and maximum penalties. This is not formality, it's insulation. Every question builds a record showing the plea is knowing, voluntary, and intelligent. The court confirms no promises, no threats, no coercion. Why? Because appeals often begin right here. If a defendant later claims confusion or pressure, this transcript becomes decisive. Notice how the judge separates the plea from sentencing authority, another safeguard. The defendant knows exactly what he's giving up: trial rights, appeal rights, and the chance to contest the evidence. This is the legal system closing one door while opening another. And here's the engagement question. If you were facing this choice over a $40 offense that escalated into criminal court, would you risk trial or take the certainty of a plea?
Yes, Your Honor.
All right, now understanding all of that, do you still wish to plead guilty?
Yes,
Yes, and to that charge, how do you plead?
guilty, Your Honor.
You understand that by pleading, you will not have a trial?
Yes, Your Honor.
Did you sign an advice of rights form?
Yes, Your Honor.
All
May I
right,
approach?
yes. Signed an advice of rights form. Do you have any question regarding those rights?
No, Your Honor.
You'll see a copy on the podium. Please look at paragraph 5. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
of your own free will
Yes, Your Honor.
and because you believe that you're indeed guilty of these offenses?
Yes, Your Honor.
On between the dates of January 22nd, 2024, and January 31st, 2024, at the location of Eastern Eateries on the EMU campus, Eastern Michigan, Washtenaw County, state of Michigan, what did you do that makes you think that you?
Yes, what did you do? No, we're talking.
I used cars without permission, Your Honor. So,
What kinds of cars?
I had used someone card without their permission.
To
So
get food?
to order a DoorDash, which was $40, and I was wrong, Your Honor.
All right, so you did that. And and in using these cards, the value of the property that you received, was that in excess of $200?
No, Your Honor. It was,
Your Honor, I'd be asking the court to take the plea.
To a higher charge for the, all right, and the court can do that. And you didn't have anybody's permission to be using these cards?
correct, Your Honor.
All right. All right. Counsel, have I complied with the court rule?
Defense is satisfied, Your
Court will accept the defendant's plea of guilty to count 3. Counts 1 and 2 are dismissed.
This is the payoff of negotiation. 2 counts gone. 1 misdemeanor remains. That's not accidental. It's strategy. The defendant admits the conduct, the prosecution secures a conviction, and the court avoids trial over a relatively low-dollar offense. But don't miss the underlying lesson. Even minor conduct can spiral into serious consequences once court orders are missed. The judge now shifts focus from guilt to compliance history, missed dates, incarceration, and future reliability. This is where credibility gets rebuilt or destroyed. The defense argues education, family support, and lesson learned. The court probes one key issue. Will he come back? Past behavior answers that question louder than promises. And yet, the judge listens. This is the court weighing punishment against rehabilitation in real time.
Pre-sentence investigation and report is ordered at 14A2 probation. Sentencing in this matter will be May 28, 2025, 10 a.m. before Judge Barr.
Your Honor, may I address the issue of bond?
Go ahead. Everybody else has some.
Your Honor, my client has, originally, he was not incarcerated. The court put him on, I believe he missed the court date. I think he had taken a trip, a family trip. He had taken a family trip. He was able to do that, but he wasn't able to make it into the next court date. I believe that's how the case went.
Yes.
So as a result, the court put him in. We're asking that now that he's pled to the misdemeanor, this is a property offense. My client is scheduled to start his classes on May 19th. We'd ask that his bond be reinstated. He'd be allowed to be released from incarceration at this time.
So is he going to be at EMU?
Macomb Community College.
Okay, so how do I know that he's going to get back here?
Oh, he'll make it back.
Huh?
He'll make it back. He has not enjoyed his time in the Washington County Jail.
Okay, so how did he come into custody?
I turned myself in, Your Honor.
You turned yourself in where? Here?
Yeah.
So he knows how to make it back here, Your Honor.
Any response from the people?
No, I would agree. I believe the defendant appeared in front of you back on May 1st and he was remanded.
Got it. That's what okay. So you know the importance of showing up now?
Yes, Your Honor.
You ever been in jail before?
No, Your Honor.
So this has been Mr. Brown's right. This has been an experience for you.
Yes, Your Honor.
Meaning you take it serious, right?
Absolutely, Your Honor.
I'll reduce the defendant's bond. I'll set it at $25,000 personal recognizance bond.
This ruling reflects conditional mercy. Judge Simpson acknowledges accountability, turning oneself in matters. Experiencing jail for the first time matters. The court uses bond not as punishment, but as leverage to ensure future compliance. A personal recognizance bond is trust-based. It says, your word is now worth something, but only because you've learned the cost of breaking it. This moment is important because it contrasts sharply with earlier revocations. Same courtroom, same judge, very different outcomes. The variable isn't sympathy, it's demonstrated responsibility. Would you consider this fair or too lenient? That question goes to the heart of how justice balances consequence and opportunity.
Thank you. It does call the case of the people versus Brendan Williams.
We're ready to start, Your Honor. Deputy Chief Public Defender Ping, Whitman on behalf of Mr. Williams.
Your name, sir?
Brendan Williams.
What are we doing?
Your Honor, we are respectfully requesting we're going to set this matter for preliminary examination. My client is currently, yes, and right now, well, there's a complication. There's a new case that's arisen. We'd like to be able to resolve these matters, but we have to know what's happening on the new case because that's going to be part of this. So it is complete for this case. We may even resolve this case short of preliminary examination, but we will need to have that other case.
The other case, does it affect this case?
Your Honor, if I can clarify, I thought we were adjourning for that purpose, but Mr. Williams has a high BAC case set for arraignment. It is out of this court. And the arraignment date that was set for his summons is June 18th. So our request was going to be that the court, I don't understand maybe not for today, but if that file could be pulled so that he could have been arraigned on his next adjourned PCC date, but we don't have one. We're setting it for exam. I had discussed with Mr. Brown that we might be able to figure out something between those two. So if we're setting it for exam, we don't need to worry about the other case. We wouldn't have time to do that.
People have their witnesses available the 27th. Preliminary examination in person, May 27th, 2025. 9 a.m. before Judge. Fresh hour. Bond will continue. Thank you.
And may we address the issue as well?
I have it at 10,000 cash surety.
And we're asking that the court consider in this case a personal recognizance bond with a tether. He does have strong family support. His aunt and his grandmother have been in the court all day today and waiting for this matter. I've spoken with his aunt. She would be willing to allow him to stay with her during the pendency of this matter.
The case, the new high BAC, what was the offense date of that?
Your Honor, the IBAC offense date is, I have it right here, that was April 3rd of 2025.
Okay, here's my problem. I've got that charge coming up, and I'm not presuming his guilt on that. But I certainly got a high level of alcohol involved in that case. That case is coming up. I've got an indication that there's alcohol involved in this case, plus then assaultive behavior is at least alleged in this case. At this time, and maybe certainly after Judge Freshour hears it, her mind will change on this, but at this time, I'm not going to reduce the defendant's bond. I'm going to deny the request for modification of bond, and we will continue.
Thank you.
Here, Judge Simpson draws a hard line. A pending high-level alcohol case plus indications of alcohol involvement in the current matter changes the risk calculus entirely. The judge explicitly states he is not presuming guilt, but risk does not require guilt. It requires patterns, and the pattern here raises concern. This is a key legal principle viewers often miss. Bond decisions are about future behavior, not past verdicts. The court chooses caution over convenience. No reduction, no modification. The case proceeds as is. This is restraint in the opposite direction, protective, not punitive. And it underscores a critical truth. When multiple cases overlap, leniency becomes exponentially harder to justify.
Court recalls the case, People versus Scott Jinx.
And then on behalf of the people, Your Honor.
And Stephanie Can on behalf of Mr. Jinx, who is appearing to my right. Mr. Jinx, please state your name for the record.
Scott B. Jenks. Help me. I did.
Did you get it? Okay. Your Honor, I've spoken to my client regarding the possibility of a self-defense argument and his desire potentially to go to trial. My client has indicated he does not want to go to trial. He is not exerting a self-defense and he would like to proceed with the plea.
All right. So you're waiving your right to assert a self-defense claim. Is that correct, sir?
Yes, sir.
All right. And so at some point during the altercation with your wife, you, without her permission, put your hands on her and pushed her down. Is that correct?
Yes, sir.
All right. Counsel, with that testimony, has the court complied with the court rule, and would it be proper to accept this defendant's pleas?
Yes, sir.
You have, Your Honor.
Court will accept the defendant's pleas of guilty to counts 3 and 4. Counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered at 14A4 probation. Sentencing in this matter will be
June 5th at 10 a.m. with Judge Freshour.
June 5th, 2025, 10 a.m. before Judge Freshour.
Your Honor, may I address bond?
You may.
Thank you. Your Honor, with this plea agreement and the felonies now being gone, I would ask my client be released on a PR bond. A part of this was treatment. He could be screened for any sort of treatment necessary. He has strong family support. His daughter is here. His daughter is here. The family home has been vacated. It's my understanding from her that the complaining witness in this case is now living with the daughter and no longer at the family home, so he can go home.
His daughter?
Yes,
Okay. So, okay, gotcha.
yes. That the complaining witness is no longer living at the family home, so he would have somewhere to go. This is his very first time doing, well, anything. My client will appear for court. He has no desire, nor will he be seeking any contact with the complaining witness in this case, Your Honor. We're asking for a PR bond.
And Your Honor, we have not had direct confirmation from the victim that she has vacated that address. We don't have a new address that she has. However, I would leave it in the court's discretion as to release. If he was to be released, Your Honor, I would ask that he be placed on a GPS tether as well as some type of testing, or alcohol testing or a scram tether.
Do I have an indication of alcohol use in these cases?
Yes, Your Honor.
There is, okay. Well, I won't put him on a GPS because we can track him from the scram tether, quite frankly, but what I'll do is I'll modify his bond. I'll give him $25,000 personal recognizance bond, so I'll release him, but he has to be placed on a scram tether prior to his release.
Once again, the scram tether appears as the court's preferred compromise. No GPS, no guesswork, just continuous monitoring. Judge Simpson recognizes family support and treatment potential, but anchors release to verification. This ruling shows consistency. When alcohol is a concern, monitoring becomes non-negotiable. The court is not closing the door, it's narrowing it. Release comes with strings, and those strings are measurable. This is modern judicial risk management, and it's becoming standard. The question for defendants is simple. Can you live within these boundaries? Because the technology doesn't argue, forget, or misinterpret.
Thank you, Your Honor.
Thank you. All right, thank you, sir. Court calls the case, People versus Martez Dalton.
Rachel McDuffie for the people.
And Maggie, on behalf of Mr. Dalton, who is appearing to my right, Your Honor.
Your name?
Martez Dalton, sir.
I told you he was on the bus. I told you you'd get here, Miss Mackey. They didn't have any faith in you. I had all the faith in the world you were gonna get here.
Your Honor, I want to thank you for passing on the matter, allowing me time to get here, sir, in the time it matter.
You know what? I had to pass it because she was just screaming at me.
Sir, I don't make no
Miss
excuses.
McDuffie wanted a bench warrant. I had faith in you, and so we gave you time.
Thank you, Your Honor. Thank you, Your Honor. I appreciate that. I was coming. I wasn't finna miss
No,
fucking Nathaniel.
I appreciate you going through the effort to get here, sir. I really.
Your Honor.
All right, and you're requesting an adjournment?
You are, Your Honor.
Grant the adjournment. What are we trying to do in this? Oh, okay, I got it. All right, so probable cause conference, May 29th, 2025, 9 a.m. Bond continued. All right.
Thank you, Your
Thank you, sir.
Honor.
Yes, sir. Thank you, Your Honor, once again.
Thank you.
This docket tells a complete story. Across dozens of minutes, Judge Simpson weighs competence, honesty, compliance, mitigation, and risk, case by case. Some defendants earn time, others lose freedom. The difference is rarely the charge alone. It's behavior under supervision, missed tests, rising levels, turning oneself in, telling the truth or not. Bond is not a reward, it's a test. And today we saw every possible outcome of that test. The broader implication is clear. Courts are increasingly relying on data, monitoring, and documented compliance to make decisions that once depended on discretion alone. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.